मैं प्योर।
Yes? क्या है? What is that?
My lord, the original picture earlier uploaded through online, my lord. This is original.
All right. Yes.
मैं प्योर।
Yes.
Matter relates to release of the vehicle which was seized under the provision of Forest Act, my lord. What happened in this case, my lord? Earlier, in the year 2015, my lord, the truck of the appellant was seized for the offence under section 33, 41 and 42 of Forest Act, my lord.
Yes.
There, having seized the truck of the appellant, my lord, a confiscation proceeding was initiated, and having received the notice in the confiscation proceeding, the appellant filed his so cause before the authorized officer, my lord.
DFO.
DFO, my lord. And learned DFO, my lord, without considering the material available on the record, my lord, confiscated the truck of the appellant, my lord, that was found by the appellate authority as well as the revisional authority, my lord. Against these all orders, my lord, the appellant approached before this honorable court and learned single judge, my lord, affirmed the order of three.
So you have
earlier
lost
orders,
from
my
all
lord.
forums.
Yes.
All right. We will
My
see
lord.
where has
My lord.
the learned single judge faulted.
Yes, my lord. Well, my first point is this, that the truck of the appellant was not seized from the protected forest area, my lord. My lord, that was seized under the jurisdiction of Nokha police station at Sasaram RR road near the village Tarbigawa, which is evident from the seizure list itself, my lord. Not only this, my lord, your lordship will find from the prosecution report and seizure list, my lord. In the prosecution report, it has been stated that the forest officials informed the SHO Nokha police station that Nokha police, and that the truck of the appellant was seized by the Nokha police station.
नहीं.
But in the seizure list, my lord.
All right. सीजर लिस्ट से भी मतलब नहीं है. जो प्रोसिक्यूशन रिपोर्ट है उसका वो पार्ट पढ़िए. दैट इज द आंसर.
यस मैम. भ्रमण के दौरान दो ट्रक अवैध
आराम से उसको पढ़िए. आपने पहला स्टेटमेंट दिया कि द व्हीकल इन क्वेश्चन वाज नॉट सीज्ड फ्रॉम द प्रोटेक्टेड फॉरेस्ट.
यस मैम.
इट वाज सीज्ड फ्रॉम अ रोड falling under the jurisdiction of Nokha police station. All right, that's a good ground.
Yes.
Now this you can support only by the prosecution report and the seizure list. Let us see what the prosecution report says.
My lord, अनुरोध पूर्वक कहना है कि दिनांक 17/8/15 को सरकारी वाहन से सशस्त्र बल एवं सहयोगी वनकर्मी के साथ सासाराम अंतर्गत बसंतपुर सुरक्षित वन भ्रमण कर रहे थे.
ठीक.
भ्रमण के दौरान देखा कि दो ट्रक अवैध बोल्डर रूपांतरित, पहले ही से
पूरा सेंटेंस कंप्लीट करिए.
पहले ही से प्रिजम्पशन है कि अवैध.
प्रोसिक्यूशन रिपोर्ट तो बाद में फाइल होता है ना. अभी तो प्रोसिक्यूशन रिपोर्ट तो जब इंफॉर्मेशन दिया, सीज हुआ, उसके बाद प्रोसिक्यूशन रिपोर्ट इज नॉट कंटेम्पोरेनियस लाइक एफआईआर. मिस्टर रजनीकांत सिंह, यू आर अवेयर ऑफ दिस. तो पहले ही से उन्होंने अपने दिमाग में नहीं बना लिया था कि हैंड ब्रोकन स्टोन्स है.
वही हम
आप पूरा पढ़ ही नहीं रहे हैं. आप जवाब वहीं पर है और आप उसको अवॉइड करिए.
ट्रक को मैंने पीछा किया, पीछा किए जाने.
ये आंसर है आपका ये इस ग्राउंड का कि प्रोटेक्टेड फॉरेस्ट में व्हीकल नहीं पाया गया. ये कहते हैं कि ऑन हॉट चेज, ऑन आइडेंटिफिकेशन ऑफ दैट व्हीकल coming from inside the protected forest area, and therefore necessary information was given to the Nokha police station. तो ये ग्राउंड आपका फेल कर गया
ना हुजूर. वहां से एट अबाउट दी मोर देन 50 किलोमीटर से हुजूर नोखा स्टेशन.
किस गाड़ी में भ्रमण कर रहे थे वो? मोटरसाइकिल पर थे, जीप पर थे
हुजूर?
कौन आपको चेज करेगा?
उसके बाद हुजूर वही क्या कहा जा रहा है उसके बाद कि थाना प्रभारी को सूचना मोबाइल से दिया और पीछा करते हुए सासाराम आरापथ है थानाध्यक्ष नोखा द्वारा दोनों ट्रकों को 70 बिगवा गांव के पास
ये हॉट चेज में पकड़ा है.
वहां तो हुजूर नोखा पुलिस स्टेशन के द्वारा गाड़ी सीज कर ली गई है. यही कह रहे हैं कि थानाध्यक्ष नोखा द्वारा दोनों ट्रकों को 70 बिगवा गांव के पास.
वो ग्राउंड नहीं चलेगा. इस पर सिंगल जज ने क्या कहा है?
कुछ नहीं हुजूर, उस पर साइलेंट है.
ऑलराइट, इस पर मैं कहूंगा
कि हॉट चेज के द्वारा हो चुकी कॉन्सिक्वेंस में आता है.
ऑलराइट, दूसरा क्या ग्राउंड है बताइए?
दूसरा थाना यहाँ एडमिटेड पोजीशन द व्हीकल ऑफ द अपीलेंट वाज सीज्ड बाय द एसएचओ नोखा, माय लॉर्ड, बट सीजर लिस्ट, माय लॉर्ड, from seizure list it is evident that the truck of the the truck of the appellant was seized by the forest officials, my lord.
with the help of नोखा पुलिस.
नो, इसमें है कि जब्ती पदाधिकारी का
आइए फॉरेस्ट प्रोड्यूस वाले ग्राउंड पर आइए. ये ग्राउंड
Yes.
तो आपका फेल कर गया.
Anyway, my lord, that is there, my lord. So next submission, my lord, the
एक ही सबमिशन है, फॉरेस्ट प्रोड्यूस पर आइए.
फॉरेस्ट प्रोड्यूस पर हुजूर, उसमें हमने रिलाई अपने किया था 2 डिसीजन को.
हाँ.
कि स्टोन्स आर नॉट फॉरेस्ट प्रोड्यूस.
नहीं, स्टोन्स आर डेफिनेटली नॉट फॉरेस्ट प्रोड्यूस
Yes, my lord.
provided those stones are not quarried from the forest area. ऐसा है कि पत्थर तो फॉरेस्ट प्रोड्यूस है नहीं ना, वो लिविंग ऑर्गेनिज्म नहीं है.
जी.
लेकिन अगर फॉरेस्ट प्रोटेक्टेड फॉरेस्ट एरिया में क्वेरिंग करके और वहां के पत्थर को तोड़ते हैं तो वो फॉरेस्ट प्रोड्यूस है. इट नीड नॉट ओनली बी वनस्पति.
देयर इज एलिगेशन ऑफ ओनली
फॉरेस्ट एक्ट का देखिए,
ट्रांसपोर्टेशन, इलीगल ट्रांसपोर्टेशन
फॉरेस्ट
ऑफ,
एक्ट का.
मतलब the allegation is transportation of illegal transportation of stone chips, my lord. There is no allegation for
आपका कहना है कि माइनर मिनरल कंसेशन रूल्स के तहत आपको प्रोसिक्यूट करना चाहिए, जिसमें प्रावधान
माइंस एंड मिनरल्स एंड कंसेशन
नहीं, और उसमें प्रावधान जो है वो फाइन देना होता है और कन्फिस्केशन भी है, जिसमें आप जाएंगे डिस्ट्रिक्ट जज के पास. वो आपका आर्गुमेंट बहुत इनोवेटिव है लेकिन चलेगा नहीं. लेट अस सी. प्रोटेक्टेड फॉरेस्ट एरिया है. वी आर सो सॉरी. यू आपने ग्राउंड ले लिया इसमें कि यू आर द ओनर ऑफ द ट्रक एंड यू हैव नो आइडिया व्हाट द ट्रक कंटेंट. ये बड़ा सेल्फ डिफीटिंग हो गया
ना. इसमें
आपने चालान कहाँ लिया कि किस जगह से आपने खरीदा है?
माय लॉर्ड, उसमें हुजूर उस पॉइंट
आप
पर
ये बताइए, किसी दुकान से अगर आप खरीदेंगे, बड़ा कॉमन सेंस अप्लाई करिए, कानून अपने आप फॉलो करेगा. ये हैंड ब्रोकन इरेगुलर स्टोन चिप्स थे जो लगता था कि हरीडली हैमर से तोड़ के आपने लोड किया, बड़े बड़े बोल्डर्स थे. दुकान से खरीदेंगे तो प्रॉपर्ली मेड स्टोन चिप्स कर देंगे. या आप स्टेल्थली सरप्टिशियसली फॉरेस्ट एरिया से निकल कर भाग रहे थे. नॉर्मली फॉरेस्ट ऑफिशियल्स ये सब देखते नहीं है या देखकर भी अनदेखा करते हैं. इसमें आपको पकड़ लिया बिकॉज यू did not negotiate. You thought that you would run away, but somehow the other they caught you.
In this, what happened in this case, my lord?
Sorry sir. फॉरेस्ट प्रोड्यूस पे बहस करिए, वो सब छोड़िए.
फॉरेस्ट प्रोड्यूस पर
32 अंक है. ये तो ये है ना, इस स्टेट अमेंडमेंट इसी में आ गया. फॉरेस्ट प्रोड्यूस इंक्लूड्स.
बिफोर लॉर्ड,
जस्ट अ मिनट, कुछ नोटिफिकेशन भी आया ना?
my lord, notification.
Mr. Sarvesh Kumar Singh, you are appearing in this matter?
Yes, my lord, section 30 may be, my lord, it comes under the forest produce, my lord. Section 2 of the definition
Section
portion, my
2(6),
lord, that
yes.
states, my lord, that it
That
is.
my brother has shown it to me.
Yes, my lord.
Now,
My lord,
with respect to protected forests,
yes, my lord,
वो
kindly
भी
come
कोई
to below
notification?
section 30 of the Indian Forest Act, my lord.
yes, power to issue notification reserving trees, etc.
Yes, my lord. My lord, section 30 clause C, my lord. Prohibit from a date fixed as aforesaid.
नहीं, वो ठीक है, that power is there. Where is the notification that this is a protected forest?
Before
Yes, my lord, that is
before C, my lord,
in the red records, my lord, annexure, last supplementary affidavit, my lord, I have annexed, my lord.
in my writ petition
In the
also,
appeal?
my lord.
In the writ records, my lord.
बोलिए.
My notification was with my writ petition also, my lord.
It's in your writ petition.
Yes, yes, my lord. Running page,
My lord,
running page 25
12 of the
writ
last
petition.
affidavit, my lord, page 12.
पहले इनके रिट पिटीशन में कहाँ लगा है उसको देखें. आपकी
25
affidavit
पेज पर प्रोसिक्यूशन रिपोर्ट के साथ ही है.
It is supplementary counter
रीट
affidavit, my
पिटीशन का पेज 25.
lord. अरे भाई,
ना ना
25
जी,
वो तो पढ़ने लायक नहीं है.
उसका टाइप कॉपी भी दिया हुआ है.
आपने कहाँ लगाया है देखें?
Supplementary counter affidavit, my lord, of the rate records, my lord, page 12. Second last page of the brief, my lord. My lord, number 1 is the Basantpur. My lord, the first line states, my lord, in exercise of power conferred by section 29 of the Forest Act 1927, the
So
government of
therefore
Bihar.
that argument also goes, ये produce है. And that also, without this notification also, from that particular area, it would include section 2.
And also clause C of section 30, my lord. That is prohibited, my lord.
नहीं, उत्तरांचल का है वो. नहीं, it's all right. Forest produce means and includes. इसका इसी का है. Peat, surface soil, rock and mineral including limestone, laterite, mineral oils and all produce. And for clarification, the notification. क्या करेंगे?
ना हुजूर उसमें लेकिन माइंस एंड मिनरल्स कंसेशन उसमें हुजूर देखा जाएगा शेड्यूल 2.
The moment it is found that it is a produce of the forest, meaning thereby that it is quarried from the protected forest area, the provisions of Indian Forest Act would apply.
But in
Nonetheless, anywhere you are not
we have
entitled
not
to
produced any cheat of document, my lord.
no, my lord. By the order of confiscating authority, my lord, only presumption is that the challan was forged and fabricated. But that challan was not verified by the competent authority, my lord. And not only this, my lord, your lordship will find from section 30, subclause B, my lord, of the Forest Act.
देखें order क्या है, confiscation order. Where has the single judge dealt with it? Where has the single judge dealt with the challan? 3 of the judgments which was cited by the appellant, that has been distinguished. But where is the discussion with respect to the argument on challan, that it was purchased and the finding that the challan was forged and fabricated? That was a ground which was relied upon by the appellant heavily. Now where is that? Let us see the order of the authority.
Good. My lord, Annexure 2 to the writ petition of the order of authorized officer, my lord.
No. The revision, the appellate authority. Authorized का छोड़िए.
That is Annexure 3 to the writ petition, my lord, running page 32.
Page
32, my lord, to the writ petition.
Which page of the order? Which page of the order?
Annexure 3, page 32.
My lord,
Writ
on the
petition.
challan, my lord, the
Writ petition.
on the challan, my lord, the argument was running page 33.
Single judgment.
Lord, paragraph 13 of the impugned order, my lord. Learned single judge has dealt with the challan, my lord.
13 page. As per the claim of the police, no challan was produced at the time of seizure of the truck. So, do you have challan in?
My lord, at that time, my lord, the vehicle along with challan which was kept in the vehicle, my lord, that was seized by the police authority, my lord. And at that time, your lordship will find from the prosecution report itself, my lord, that the vehicle was seized by the Nokha police station, my lord, but in the seizure list, my lord, the forest officials has seized the truck in question, my
He
lord.
hardly matters.
And during the course of proceeding, my lord, the challan was produced. The challan was that was never verified by any competent authority, my lord, which is evident from the order of the authorized officer as well as the
Very challan in this read.
yes.
On which page?
My lord, kindly come to page 28, my lord, of the
Read.
yes, my lord, read of the order of passed by the authorized officer, my lord.
28 of read. Page
Read
28.
petition,
read.
my lord. Yes.
पेज 28 पर हो जाए।
हुजूर, सरकार की तरफ से विशेष लोक अभियोजन उपस्थित उनके द्वारा सरकार का पक्ष रखते हुए इस न्यायालय को बताया कि उपरोक्त प्रावधान ट्रक निबंधन सुवर्ण 100 द्वारा पत्थर निबंधन संख्या सुवर्ण 100 द्वारा इतना फुट पत्थर मिट्टी का जब्ती
चालान
बसन
का जिक्र है हुजूर लास्ट सेकंड पैराग्राफ उसी पेज में चालान पूछा गया।
उसी में हुजूर आगे आता है बसंतपुर अधिसूचित सुरक्षित वन क्षेत्र के उत्खनित एवं रूपांतरित पत्थर मीटर अवैध निष्कासन परिवहन वन अपराध में संलिप्त रहने के कारण भारतीय वन नेक्स्ट पैराग्राफ में लौट आगे बहस में विशेष लोक अभियोजक द्वारा यह भी बताया गया कि जब्त वाहन ट्रक निबंधन संख्या सुवर्ण 100 निबंधन सुवर्ण 100 वन क्षेत्र में अवैध उत्खनन एवं रूपांतरित पत्थर मेटल गिट्टी लदे होने के कारण घटनास्थल पर वाहन के ऊपर लदा मेटल गिट्टी के बीच संबंधित वाहन चालक खलासी वाहन स्वामी द्वारा पत्थर मेटल से संबंधित कोई पक्ष खनिज परिवहन चालान क्रय रसीद टोल टैक्स रसीद जब्ती पदाधिकारी के समक्ष प्रस्तुत नहीं किया गया है
सेकंड लास्ट
और न ही जब्ती पदाधिकारी द्वारा वरीय पदाधिकारी के समक्ष प्रस्तुत करने का वाहन को उपरोक्त प्रासंगिक वन अपराध में सम्मिलित होने की किया गया।
उसी पेज में हुजूर लास्ट सेकंड पैराग्राफ देखा जाएगा उसी पेज में जहां हमारे लर्नर फ्रेंड पढ़ रहे हैं। प्रतिवादी पक्ष द्वारा घटना स्थल पर पत्थर मेटल गिट्टी के परिवहन से संबंधित वैध कागजात प्रस्तुत नहीं करना तथा जब्ती के उपरांत फर्जी तरीके से परिवहन चालान बनवाकर
वकील साहब उस पर ज्यादा जोर मत दीजिए। It was also verified and it was found that the purchaser was Vidya Shankar and Vijay Singh.
Yes, my lord.
You are Anil Singh.
Anil Singh, the owner of the
vehicle.
My lord.
Now, nobody has claimed, no person has claimed that stone chips.
My lord.
And therefore,
absolutely, my lord, nobody came forward to claim the chalan, my lord.
That's right.
Claim the.
And therefore, all the authorities came to this conclusion that number one.
Only there is presumption, my lord. वही हम हुजूर को दिखा रहे हैं कि उपरांत जब्ती के उपरांत फर्जी तरीके से परिवहन चालान बनवाकर that चालान was never verified by the any competent authority. Not only this, my lord, I have especially pleaded in my writ application in para 18, my lord.
Yes.
In 18 of my writ petition, my lord.
Yes.
The respondents have failed to appreciate that the forest authority has no jurisdiction to switch the vehicle out of protected forest, and the informant did not turn up for deposing in the court, and his non-examination in the court, my lord, vitiate the entire prosecution story. Your lordship will find from the order of authorized officer only 2 witnesses were turned up by the appellant, my lord, but nobody was turned up by the prosecution side to.
Sorry. Heard Mr. Rajnikant Singh, learned advocate for the appellant, and Mr. Sarvesh Kumar Singh, learned
only on the basis of prosecution report, my lord, the entire order has been passed, my lord, and there is nothing. Challan was never verified. No one came forward in support of the prosecution case, my lord. Only presumption is there. जो कहीं ट्रक पकड़ा रहा है कि या तो फॉरेस्ट
बड़ा
प्रोटेक्टेड
strict liability है. The Supreme Court and most of the high courts, including this bench, judgments authored by one of us, Justice Ashutosh Kumar,
Yes, my lord, in the full bench, my lord.
it has to be construed in a very strict term. Heard Mr. Rajnikant Singh, learned advocate for the appellant, and Mr. Sarvesh Kumar Singh, learned additional advocate
May I
general.
pray one thing, my lord? There is provision of compounding, my lord. Section 68 of the Forest Act.
That's over now. That's over now. That you can't possibly.
My lord, the dominion of property now vests in the government, my lord. In
आप
terms of
क्या
section
compound
60.
करेंगे? वो तो खत्म हो
Unless you
गया.
compounded, how can you claim? Unless you have already compounded, you can't claim.
Mother, that point was raised before all the authority.
देखिए, let the court dictate the order. So and so लिखा ना. Heard Mr. So and so. The appellant, who is the owner of the vehicle which has been seized and confiscated, has challenged the order passed by the learned single judge in CWJC number 8472 of 2020. So stop. The grievance of the appellant is that, like the other courts, the learned single judge also did not take into account the fact that no attempt was made by the authorities to verify the genuineness of the challan through which stone chips, which was alleged to be the forest produce, was purchased by the buyer. The case, it appears from the records that the vehicle belonging to the appellant was spotted by the forest officer while patrolling in the protected forest area, who immediately informed the Noka police station to intercept the vehicle. The vehicle was intercepted and it was found that it was loaded with freshly hand broken stone chips. Since the vehicle was found to be crossing the protected forest area and was found to be laden with stone chips, the vehicle along with the stone chips was seized under the provisions of the Forest Act for violation of the notification prohibiting any quarrying in the protected forest area or transporting the forest produce, including stone chips quarried from the protected forest area. The vehicle as well as the stone chips were subjected to confiscation proceedings. The order of confiscation was passed by the DFO, which order appears to have been sustained by the appellate as well as the revisional authority. The Land Council for the appellant has submitted that the vehicle admittedly was seized from the road, and therefore it is only the presumption of the prosecuting agency / forest authorities that it had crossed the forest area. The vehicle had been seized by Noka police. He therefore submits that the accusation of the vehicle being intercepted on hot chase while it was coming out of the protected forest area was incorrect, and only for the purposes of justifying the interception, the seizure and ultimate confiscation. He further submits that only because nobody came forward to claim the stone chips, that would be no ground to presume that the appellant was the owner of the stone chips who actually had caused such transportation. Lastly, it was submitted that even if a challan was produced in justification of the stone chips having been purchased from the market, without proper verification of the genuineness of the aforesaid challan, no presumption could have been drawn. Before the learned single judge, several case laws were placed in support of the contention that stone chips cannot be stated to be forest produce. The learned single judge, after having examined all such cases, bracket में लिखना, Alok Kumar Singh versus State of Bihar, 2019, bracket 4, PLJR 1026, semicolon, DFO, South Kamrup Division, Guwahati and others, versus Moolchand Sarogi Jain, AIR 1971, Supreme Court 694, semicolon, Bejiram Ingti versus State of Assam, 1982, Guwahati 88, found that such declaration was in a different context, which did not take into account that in the present case, the stone chips was found to be loaded on a vehicle which was intercepted when it came out of the protected forest area. Taking into account the aforesaid facts, namely the seizure of the vehicle on hot chase, the vehicle being loaded with stone chips, which was found to have been quarried from the protected forest area, and nobody else coming forward to claim the stone chips, the vehicle was seized and was confiscated. The learned single judge therefore did not find any reason to interfere with the orders of the authorities in succession, Mr. Sarvesh Kumar Singh, learned Additional Advocate General number 13, has defended the order passed by the learned single judge by stating that the definition of forest produce in the Indian Forest Act 1927 would include rock and minerals, including limestone, laterite, mineral oils, and all products of mines or quarries, within big bracket in italics, पूरा section 2 interpretation clause, पूरा section 2 को quote कर देना. Apart from this, it has been submitted that in exercise of the powers conferred on the government under section 30 of the Forest Act, a notification also has been issued declaring the Basantpur forest area to be protected forest.
Under section 29, my lord.
Under section 29 of the Forest Act, Basantpur forest area is protected forests. Thus it has been contended that there could be no other opinion except that the vehicle in question was transporting the forest produce in the shape of stone chips, and therefore there was nothing wrong in confiscating the vehicle. After having heard the Land Council for the parties, we have found that even the challan which was produced later did not match with the statement made by the appellant. The challan, from the challan it appeared that the purchasers were Vidya Shankar and Vijay Singh. First up, since nobody came forward to claim the stone chips, and the appellant, though only contested the confiscation of the vehicle which stands in his name, it was not highly inappropriate to presume that the appellant, that the stone chips was consciously being carried / transported by the vehicle which stands in the name of the appellant and which has now been confiscated. Apart from this, the circumstances of the case clearly indicate that the vehicle was coming out of the protected forest area when it was intercepted. The provisions of the Forest Act are required to be strictly complied with and followed for the purposes of achieving the object for which the act was enacted. Any other approach in the matter of confiscation would be uncalled for, as it is likely to frustrate the provisions of the act. We further find that the forest authorities, as also the appellate and the revisional authorities, have given reasons to justify the interception and confiscation of the vehicle and the stone chips which was loaded on it. The learned single judge has rightly distinguished the cases referred to above. In all such cases, the stone chips in question was not alleged to have been quarried from any forest area. Thus, any declaration of such stone chips not being forest produce would not be relevant for the purposes of this case. The contention of the appellant that if at all any proceeding was required to be initiated against him, it was under the Bihar minor mineral concession rules, is not acceptable. No sooner it is found that the stone chips is quarried from the forest, from the protected forest, it becomes a forest produce in terms of section 2 of the Forest Act and the notification of the government issued by exercising the powers under section 29 of the Indian Forest Act. We find no reason thus to interfere with the order passed by the learned single judge. The petition is dismissed. The appeal is dismissed.
Judgment.